Massie for 5 minutes.
Thank you, Madam Chairwoman, for holding this very important hearing on a very important topic. Before I jump into facial recognition, I want to talk about name recognition. Imagine a system, a computerized system, that instead of basing the adjudication of your civil rights on the distance between your eyes or the shape of your nose or where your ears are in relation to your cheekbones, it's based on the spelling of your first and last name and your birthday, and whether you might share a same name with somebody who's been convicted of a felony or may be in prison today. Well, such a system exists, and there is no judge or jury involved. It's called the NICS background check system. And the troubling thing about facial recognition as it exists today is there may be racial disparities in it, but we know that there are racial disparities in the NICS instant background check system. That's the system that you have to go through in order to purchase a firearm. And my friend John Lott, who worked at the DOJ recently, has found evidence that this system, by a factor of 3 to 1, produces false denials for Black males compared to white males, because they may share a similar name to somebody who is incarcerated within their ethnic group. And so, Ms. Goodwin, I appreciate the good work that the GAO does. You all do great work. I served on the oversight committee. We covered this topic before there, the facial recognition topic. The GAO released a report that said there were 112,000 denials based on the instant background check and only 12 federal prosecutions. Ostensibly 100,000 people committed a crime by trying to buy a firearm when they were ineligible. What we know from that is actually that they didn't commit a crime, but there were a lot of false positives. I got the commitment of FBI Director Wray in one of our recent hearings to look into this issue about whether there are racial disparities built into the instant background check system, because it's not very technologically advanced at all. And he said he would work on it. But I hope if this comes across your desk and that you have an opportunity that you might look into it. Is this something that your part of the GAO would examine?
Thank you, Congressman. And actually, that was my report. I worked on that report, the prohibited purchases report. So we are happy to have a conversation with you about additional work we can do in that area. Wonderful.
Thank you so much. And thank you for that report. They do collect race information on the form 4473. And so if we could, just take another level, it wouldn't have to be as deep and thorough as the report that you did already, but it would be very helpful, I think. I noticed that the beginning of this recent report on facial recognition started with, or your testimony, we surveyed 42 federal agencies with, law enforcement employees or internal law enforcement. And I thought, whoa, stop right there. That to me is troubling, that we have 42 federal agencies that have law enforcement. Maybe this is something that Democrats and Republicans could get together on. Maybe we have too many organizations. If the Department of Education has a police force, then maybe we have too many police forces at the federal level. But moving on, I wanted to ask one of our professors here, maybe Professor Lauren, about Brady material. Possible exculpatory evidence that's produced and that the prosecution may not want to share with the defense. And you mentioned that the way they get around some of the typical safeguards is they say, oh, we just used it to identify the suspect and we're not using it for the conviction. Can you talk about how that's problematic and whether defense attorneys can get Brady material from facial recognition companies?
Thank you for the question. In terms of I'll start with the last piece that you mentioned, which is getting Brady material from companies. In other words, there may be instances where, assuming a world that we don't quite live in yet, right, where facial recognition matches, say, are actually introduced in evidence in a criminal case. In those instances, the defense would certainly want to, and a competent defense would, sort of interrogate, right, what's inside the black box that generated this match, right? Well, one of the complicating features here is the proprietary nature of many of these technologies. And so we haven't seen this yet so much in the facial recognition context, but we have seen it actually in the context of DNA with certain more novel analyses of low copy DNA, et cetera, where the defense has been denied the ability to access the source codes, access what is claimed by companies to be proprietary information protected by trade secrets, and that intellectual property law has been invoked to quash defense subpoenas. So one of the many complicating features here, one of the many limits on the ability of the defense to vet this in a criminal context is this proprietary dynamic. Layered on top of that are a number of complications that derive from Brady doctrine and sort of disagreement over the scope of Brady and deciding when defendants are entitled to what we would call Brady material ex ante versus after the fact. I know you have limited time. I'm happy to pause there.
I see my time has expired, and I just want to say I hope Congress will weigh in on this instead of like the Brady doctrine, allowing the courts to write this for us, because it does seem to be a problem, not just within facial recognition or yet, but with across all the domains. And I yield back.
Thank you very much. I now recognize the gentleman who has dealt with some of these tech issues from a different perspective, gentleman from Rhode